To Your Money this week, which is sponsored by the Stamm Lawfirm. The attorneys are walking us through what happens in the probate process after someone dies. To Your Side's Kelly Dudzik asked them to explain how this part of the legal system works.
When you pass away, someone in your family, the oldest child, your sister or brother, or a nephew or a niece, right, or your spouse, will have to go to probate. Whether you have a will or you don't, every will has to go to probate.
Attorney Brian Stamm says the first step in probate or the surrogate's court is to apply to the court with a petition. You also have to gather a lot of documents.
You have to get affidavits, you have to get petitions, you have to get notary signatures. Then once you do that, 2 months go by, 3 months go by. Then you get appointed, either the executor of the will or the administrator of the estate if they die without a will. So that takes a couple months.
And his brother, attorney Bradley Stamm, says if a will or estate goes through probate, you won't be able to instantly access money left behind when someone dies.
Until someone's appointed by the surrogate court, everything's frozen. And that's scary to people. But it's a process, and that's why sometimes we tell people, let's try to avoid that.
They explain that you can avoid probate by naming beneficiaries when you can or by creating trusts, and say that things can happen during the probate process to delay payouts.
What if there's infighting in the family?
Which is common.
Dad didn't sign that. That's not his signature. You know, mom never wanted this as her estate plan. Well, guess what? Now you're entering the world of estate litigation on top of surrogate court approving the will and going through the probate process.
How do you end up resolving things if this is the path that you're in and you have no other way to go?
Well, eventually, the court will make determinations. You are the executor, you are the administrator. Now they have an obligation. Gather the assets, pay any bills that are owed, make sure the house is sold. So that executor or administrator finally has the authority to act. That's what Brad was saying before. You go to the bank, they say you don't have authority. So you need authority to act. So finally you do, but then you have to do an accounting. And people can object to the accounting. People could say, what happened to that furniture? What happened to mom's car?
We try to avoid those conflicts and get things resolved. But I'll tell you, there are times it's really tough.
On Your Side, Kelly Dudzik, Channel 2 News.